Further hearing the appeal, Bloomberg LP ZXC.
Yes, Mr. Redden.
My Lords, part one, why we say, in summary, that Bloomberg's argument is a distortion of the lower court's reasoning. My Lords, we say in our printed case that it's based on three overarching errors, which we identify at paragraphs 56 to 60, that's E148 to 149. We say there, and I'll outline them in this part, we say there are 7 reasons why that characterization is wrong. But can I just summarize what we say the caricature or distortion is of the lower court's reasoning? It's said that both Mr. Justice Nicklin and the Court of Appeal applied an inflexible general rule which fettered their approach to what Bloomberg accept is the first fact-sensitive question in all misuse of private information claims, namely the reasonable expectation of privacy. And in applying that inflexible general rule, it's argued the Court of Appeal and Mr. Justice Nicklin overlooked or failed somehow to apply the Murray requirement to consider all the circumstances. According to Bloomberg, the rationale of the lower courts for the rigid general rule was a concern to protect ZXC from unwanted reputational damage, contrary to Supreme Court authority concerning the public understanding of the presumption of innocence, that's Guardian News and Cuja, as well as defamation law. Bloomberg then argued that the approach of the lower courts amounts to holding that information about an individual being subject to investigation is private solely because it is reputationally damaging, thereby obscuring the correct approach to identifying information that will engage privacy rights, which requires, says Mr. White, a focus on the nature of the criminal activity which is being investigated rather than the status of being a person, a mere suspect under investigation. So that's his activity point. Bloomberg further claimed that the lower courts drew an artificial distinction between the criminal activity under investigation, on which the media is free to report based on its own inquiries, and the UKLEB's own private confidential assessment of ZXC's behaviour in the light of the evidence the UKLEB, has acquired. And according to Bloomberg, the justification for drawing a distinction between these two categories of information was grounded in reputational concerns, but that it amounts to a distinction without a difference, and it offends the conduct rule in defamation, says Mr. White. Having mischaracterized the nature of the activity in which ZXC was engaged, say Bloomberg, this tainted the judge's approach to the Murray factors. The judge applied the factors identified in Murray, says Mr. White, to the wrong information. The judge should have focused on the activity of alleged corruption or bribery by ZXC in a foreign country rather than the activity of being the suspect of the UKLEB's investigation into the alleged corruption. And finally, Bloomberg contend that both in relation to the Stage 1 and Stage 2 tests, the lower courts wrongly conflated confidential information with private information and ignored the fact that in order to be ZXC's private information, it had to relate to his private life, whereas the information related to his business activities as the chief executive of a division of a listed company rather than his private life. And at Stage 2, Bloomberg say, the judge of the Court of Appeal applied the wrong test to assessing the public interest justification because they were wrongly fixated on the confidential nature of the letter of request. And it said that there is no principal distinction to be drawn between discovering facts from a confidential document and any other kind of journalistic investigation or inquiry. Now, we say that is a great respect, a caricature of the judgments of the lower courts, and we make these 7 points. Firstly, there was no rigid rule applied. Neither Mr. Justice Nicklin nor the Court of Appeal applied a rigid rule which ousted proper consideration of all the circumstances of the case in finding, in light of the recent case law as well as public policy statements, a general rule that a person under a criminal investigation has a reasonable expectation of privacy. Both courts were at pains to make clear that it is not an invariable or inflexible rule. It is merely a starting point and ultimately depends on the facts of each case. And just without going to it, for your note, we quote in paragraph 23 of our printed case at E139 the references in the various judgments. With respect, I adopt the point that my Lord Sales put to Mr. White, that when a court approaches this type of question, it is always going to be helpful in terms of structuring the decision-making to try and identify a starting point for consideration. Let's leave this category of information, being a suspect under investigation, and look at medical records. Presumably, my learned friend would object if there was a general rule or starting point that medical records there's a reasonable expectation of privacy in relation to medical records.
I mean, at the end of the day, this is a tort, and one can't say that whether a tortious liability arises or not is simply a matter of throwing all the factors up in the air and seeing how they land. I mean, there have to be some guiding principles in the law.
Precisely. Well, I agree, Lord, with respect. Quite apart from anything else, in order to be able to give useful advice about whether the claim is arguable.
Well, also, I mean, it's a legal liability. The law of tort imposes legal obligations upon people.
Yeah.
And they have to. It's elementary that, to be consistent with the rule of law, it has to be predictable.
Yes.
When such an obligation will arise.
Yes. Yeah. And the court, all the courts below, simply indicated that this is a category of information in which you begin the exercise on the basis that this is already recognised as a category of information that engages Article 8 and requires justification. I mean, if you take the medical records, you'd always say, I suggest, that Article 8 is engaged by publishing someone's medical records. Of course, there may be, I mean, take an extreme example, let's say a prime minister or president who's got fingers on the nuclear button. There's medical evidence that he or she's suffering from dementia or some cognitive impairment. It may well be justified then to publish that person's medical records. But the starting point is Article 8 is engaged by the exercise. So in our submission, point 1, there was here no rigid rule. There was simply a starting point, which is a necessary requirement in this type of exercise. And secondly, and linked to it, in considering whether the general rule applied on the facts of this case, both Mr. Justice Nicklin and the Court of Appeal clearly did take into account the Murray factors, and on the basis of all the relevant circumstances held that his privacy rights were engaged. It's an ambitious argument that they didn't do that, and the references in the judgments, again, I won't take you to them. Mr. Justice Nicklin, paragraph 125 at page 367, and the Court of Appeal, paragraph 69 to 88, pages 249 to 253.
Can I just check? Are you giving us open judgment
Yes,
references?
I am.
Yes, okay.
All the way through. And so once that reality is understood with great respect, the central thrust of Malone Friends' critique simply falls away. Thirdly, it's clear that in reaching the decision they did, the lower courts did not decide that Article 8 was engaged merely because of the adverse effect that publication had on ZXC's reputation. Again, without taking you to it, Mr. Justice Nicklin, open judgment, page 125, paragraph 125, E368 to 371, he explains the basis on which he's making finding Article 8 engaged, and in particular, paragraph 125, little 1, subparagraph F, on page 369, he cites ZXC's evidence concerning his outrage and anger in relation to the article and commented that this is a complaint about loss of autonomy and damage to reputation, rightly observing that both are dimensions of the Article 8 right. And at paragraphs 153 and 155 from his open judgment, 379 to 380, publication of the information negatively impacted not only on ZXC's reputation, but also upon his autonomy, dignity, standing, family life, and emotional well-being, all matters that fall within Article 8. Fourthly, there was, we respectfully submit, nothing inconsistent as between the analysis of the judge and the Court of Appeal and the discussion of the public understanding of the presumption of innocence in Cuja and the Guardian News and Media case. On the contrary, it reflects precisely the observations of Lord Sumption in Cuja and his analysis of what Lord Roger is to be understood as having said in the Guardian News and Media case, as well as the view of the minority judgment of Lords Kerr and Wilson. Indeed, in addition to the points that we make in our case at 61 to 64, E149 to 152, it bears noting that even in the Guardian News and Media case, notwithstanding his observations about the presumption of public understanding of the presumption of innocence, Lord Roger proceeded on the basis that publicly naming the claimant as someone suspected of terrorism would engage Article 8(1) rights. That is clear from paragraphs 43 and 44 of his judgment, or his in the Guardian case, that's E1147, as well as paragraph 52, E1149. Lord Roger's observations about the public understanding about the presumption of innocence were not directed to the question of whether Article 8 was engaged, but rather the separate issue of whether the undoubted interference with that Article 8 right was justified on the basis of countervailing Article 10 considerations. And could I just make this observation on the Guardian News case? My Lord Reid said yesterday that it was a fair trial case.
Yes, I was mistaken.
Yes, it was the case in which three individuals had been made the subject of freezing orders under the legislation designed to restrict terrorist financing, and there had been a court process which had resulted in the orders being made. And up until the case reached the Supreme Court, it was in fact the first case to be heard by the Supreme Court, up until that point, they had been anonymized. And the issue that the Guardian then raised when the case reached the Supreme Court was whether that anonymity was justified. And as the court knows, this court held that on balancing the Article 8 right against Article 10, the anonymity could not be justified. And one of the reasons was there has been a public court process which has resulted in the making of orders that was a fair hearing, and the issue of restricting terrorist funding was a matter of legitimate public interest. And indeed, the Treasury's motivation in making the orders was designed to ensure that people, in effect, knew that these are people you should not be dealing with because their assets are frozen. And so, I mean, the case, as I said, isn't an article fair trial case, but it's light years away from the circumstances of this case. And in any event, as I say, Lord Roger's observations were in the context of him accepting that Article 8 was engaged by the naming of these individuals. My learned friend's reliance on the defamation case law, we say, is misconceived in circumstances where an allegation that someone is under investigation is considered defamatory because of what it implies, namely that there are grounds for an investigation or for suspicion of guilt. If my learned friend is right about this, the public understanding of the presumption of innocence would necessarily mean that an allegation that someone is under investigation for a criminal offence was not defamatory, because the public would presume they were innocent. But that actually is not the position. Fifthly, the courts, we say, were clearly aware that ZXC was not asserting privacy over the alleged underlying criminal conduct while working for his former company, but rather the sensitive, confidential, private views and thinking of the UK LEB about his conduct. And there is, we say, self-evidently a distinction between an article reporting about an individual's alleged criminal conduct and an article reporting about the police investigation into that individual and the preliminary private conclusions drawn from those investigations as set out in a confidential letter of request. And as Lord Justice Underhill neatly put it at paragraph 150, open judgment E265, information that an individual is the subject of a formal criminal investigation is genuinely of a different character from allegations about the conduct that is being investigated. And Lord Justice Simon said something to similar effect in paragraph 96 on E254. I won't take you to it. My learned friend's argument, I'll develop this a bit more fully because it will save time later. If my learned friend's argument is in effect that if the courts had focused here on the activity instead of the UK LEB's suspicions, they would have been bound, in effect, to find that Article 8 was not even engaged because the activity itself, the conduct, related to or took place in the context of a person's professional or business life. And he relied and spent some time on this by looking at various case law, including Kinloch, JR 38, and Sutherland. I make the obvious point that all of that was made to Mr. White in his submissions, that the factual situations in those cases are totally different from the one we are faced with. Kinloch, for example, and Sutherland, they were cases about the admissibility of evidence in proceedings, effectively, and as to whether the breach that was alleged of Article 8 meant that you could not use the evidence. And that's a completely different scenario from the one that we are concerned with. And I do say that my learned friend's attempt to distinguish between the engagement of Article 8 in relation to private criminal activity, such as sexual abuse allegations, and public criminal activity is both unworkable as a bright line principle and produces absurd outcomes. The reality is that almost all criminal activity, once proved to have taken place, is out with Article 8 protection. Of course, and it was said in the case of T and Chief Constable of Greater Manchester, the fact that a person's criminal past has receded into history can result in Article 8 being re-engaged. But the point is, generally, once the activity is shown to have taken place, then all of it is going to be outside Article 8 protection. And the absurd example, if postulate these facts, a businessman is on a business trip with a colleague, a female colleague, and at one point he or they are handing a bag of cash to bribe somebody in a private hotel room, and then after the person takes the bribe and leaves, the businessman then is alleged to have raped the colleague or sexually assaulted her. On my learned friend's approach, is it suggested that, well, the act of handing the cash over doesn't engage Article 8 because it's some public or business activity, but the act of allegedly raping a colleague does attract protection because it's to do with sexual behavior. In my submission, that would be an absurd outcome. The reality is that both activity, if they take place, if it's true that that's what was going on, would not ultimately attract Article 8 protection. But we are at the stage of whether, before a charge is brought or an arrest even has taken place, allegations are being made at an early stage about a person's alleged criminal conduct. In our submission, Lord Justice Simon was right to approach this issue on the basis that it's the status and the fact it's at an early stage, before view has even been formed that there's enough information to charge somebody or even arrest them. And it's really it's the charge point at which the event becomes public, because there then will be an appearance in court and so on. So, but up until that point, one is dealing with a completely different state of affairs. In relation to the JR 38 and Kinloch point, can I just show you some passages in JR 38 to make this point? We say that JR 38 supports our case that for the purposes of whether there is a reasonable expectation of privacy in respect of information about an individual's suspected involvement in criminal activity, you don't simply ask whether there's an expectation of privacy in relation to the activity itself. My learned friend cited JR 38 for the proposition that for the purposes of considering Article 8, one must always ask whether the underlying activity which the claimant is involved in is an activity in respect of which there's a reasonable expectation of privacy. But as we point out in para 90 subparagraph 2 of our printed case at E159, both Lord Toulson and Lord Clark made it clear that the publication of the same thing, the photograph in JR 38, could engage Article 8.1 if it was done for a different purpose. Could we just look at that case? It's at page E1283. At paragraph 98, Lord Toulson said, "I don't agree with Lord Kerr's suggestion that the test of reasonable expectation of privacy or legitimate expectation of protection excludes from consideration such factors as the age of the person involved, the presence or absence of consent to publication, the context of the activity, or the use to which the public material is to be put. The reasonable legitimate expectation test is an objective test. It's to be applied broadly, taking account of all the circumstances and so on. Thus, for example, the publication of a photograph of a young person acting in a criminal manner for the purpose of enabling the police to discover his identity may not fall within the scope of the protection of personal autonomy, which is the purpose of Article 8. But the publication of the same photograph for another purpose might." So that's a distinction that he drew. And then at paragraph 101, E1284, he says at the beginning, "I should make it clear I don't suggest that there could never be circumstances in which publication of the photographs which are the subject of this case would fall within the scope of the appellant's Article 8 rights. Photographs can become historic, and republication material which was once properly in the public domain may give rise to a valid complaint." And then he cites Cat. And Lord Clark at 112, para 112, on page 1287, he said, "I agree with Lord Toulson on the facts here. The criminal nature of what the appellant was doing was not an aspect of his private life that he was entitled to keep private. He could not have had an objectively reasonable expectation that such photographs, taken for the limited purpose of identifying who he was, would not be published. I would not, however, hold that the mere fact that a person is photographed in the course of a criminal activity deprives him or her from the right to prevent the police from publishing the photographs. Thus, if the photographs had been published for some reason other than identification, the position would have been different. and might well have engaged his rights to respect for his private life within Article 8.1. And so that makes it absolutely clear that even though the criminal nature of what he was doing was not an aspect of his private life he was entitled to keep private, the public revelation of that information could, depending on the underlying purpose of the revelation, constitute an interference with the appellant's right to respect for his private life. And so that line of case law itself, JR 38, Kinloch and others, does not hold out any absolute rules in this field. One is always looking at the purpose for which activity which has taken place in public and may have been recorded either by photograph or CCTV. You have to look at the purpose for which it is being used. We do say it would create enormous uncertainty in the law if the underlying criminal conduct in each case, the example I've just given of so-called private and public criminal activity, it would create enormous uncertainty. And I adopt respectfully the point my Lord Reid put to me of the need to have some clarity here, to suggest that the distinction is the nature of the activity rather than the status of being a suspect. And we make the point that no distinction is made about reporting the names of suspects is found either in Sir Brian Levison's report, the College of Policing Media Guidance, the IOPC, the Home Affairs Select Committee, or the government's statement on this issue. And all of those documents and reports are summarised or quoted from in paragraphs 46 to 45 of our case, which is E114. And so we say that Lord Justice Simon was right in paragraph 84 of the open judgment at page 252, when he said that the reasonable expectation of privacy is not in general dependent on the type of crime being investigated or the public characteristics of the suspect.
I'm sorry, which was the paragraph?
My Lord, that's paragraph 84.
Thank you.
I won't read it out, but I think you may recall the paragraph. To be suspected of a crime is damaging, whatever the nature of the crime. It's sensitive personal information. There could be little justification for a hierarchy of offences giving rise to suspicion. Sorry, that was a slightly lengthy point 5, but I finished what I was planning to say about that. 6 of my 7 points, neither at stage 1 nor at stage 2, we say, did the lower courts conflate confidential information with private information. Rather, they simply relied on the fact that the information was contained in a highly confidential letter of request as but one relevant factor, albeit a highly relevant one, the most significant factor, when holding that ZXC had a reasonable expectation of privacy. And we say in doing that, the courts below were applying a completely conventional multifactorial Murray assessment. Bloomberg agreed that the test that the judge needed to apply was to consider the circumstances in which and the purpose for which the information came into the hands of the publisher. That's criteria or the last factor identified in Murray. But Bloomberg's case effectively amounts to an argument that the lower court should then have entirely disregarded the fact that the information emanated from a highly confidential law enforcement document provided to Bloomberg in a serious and almost certainly criminal breach of confidence, and that its publication to Bloomberg threatened to imperil, by Bloomberg rather, threatened to imperil a live criminal investigation. I mean, this document had not even got to the stage at which the foreign government was being asked to respond to it. This was in the middle of a live criminal investigation. It was containing the suspicions of the law enforcement body and the evidence it was seeking. And the idea that fact was irrelevant or should have been almost disregarded and just look at what the information was saying is, in my submission, an impossible argument. I make this point, it's not in our case, but it's a point that occurred to us after. If Bloomberg or any media organization had made a freedom of information request for this information, they could not have got it. Because, and we can perhaps email you the relevant provisions in Section 30 of the Freedom of Information Act, but this category of material is excluded from disclosure under Freedom of Information legislation. It's just an additional point, really, which emphasizes the inherently private and confidential nature of this document. Seventhly, finally, on this part of my case, Malone and Friends' warning that the lower court's rulings threaten to outflank established principles of the law of defamation with consequential restrictions on freedom of information, freedom of expression, is, we say, without any foundation. I mean, here, no damages for injury for reputation were ultimately sought or awarded. There's no question here of ZXC being compensated for harm to an unwarranted reputation or of Bloomberg being wrongly denied an opportunity to defend the information as true. ZXC did not advance a case on falsity, and he didn't contend that the article meant he was guilty of any offences of fraud or bribery. He didn't accept the information was true, but he simply wasn't advancing a case of falsity. And his objection was to the publication of true facts, the details of the investigation into him, and the preliminary conclusions of the UK LEB about his guilt of serious offences. And the unappealed award of damages in this case was limited to non-reputational categories of harm caused by the publication of true but highly sensitive information, into which we say he plainly had a reasonable expectation of privacy, and whose publication he sought to injunct as his main goal. Mr. Justice Nicklin made the point, paragraph 136 at E374. He said the claimant has been consistent throughout his claim that the primary remedy he seeks is an injunction. I do suggest that Malone Friends' real aim here, in effect, pursuing an argument on behalf of the media, the real aim in pursuing the outflanking argument is to effectively eviscerate the MOPI tort altogether in relation to criminal suspects, leaving the press unfettered by legal constraint to be the judges in their own cause as to what details can be published about suspects prior to the formality of a charging decision. It's crucial to the argument to knock out Article 8.1 altogether at stage 1, because once it's engaged on the facts of this case, as I've made clear, it is really an impossible task to suggest that they got the balance wrong on the facts of this case. And I do submit that such an outcome, effectively neutering or removing this tort altogether in relation to this category of information, would fly in the face of authority at the highest level domestically, as well as in Strasbourg, as well as being contrary to the clearly emergent consensus on this issue, as reflected in the various documents and public policy statements. And so with that, I move to part 2.
Which you do so, is it possible to award damages for reputation in misuse of private information?
Yes, well, I say there could be cases in which you could. And I was going to come to that in a bit more detail later on. But yes, my Lord, I do say in some cases you could. And as Lord Sumption has said, one of the purposes of the privacy tort is an alternative method of protecting reputation. And I say, for example, in the example that my Lord Reid gave of the TV presenter about whom medical records are published, which are true but harm reputation, yes, the fact they're true wouldn't prevent reputational damages being awarded.
True, and can you help me on
the difference, if there is a difference, between reputation and standing?
My Lord, I acknowledge they are closely linked and they may well overlap. The reality is that the objection is that where you are running a reputational claim in the area of criminal behavior, my learned friend's real complaint is you need to be able to defend the allegation as true, otherwise you are outflanked and you get a remedy on an unfair basis and damages could be awarded. But the answer to my Lord's question is that it may appear sophistry to distinguish reputation from standing. The key thing is that you award, as happened in ZXC's case, you award the damages on a basis which is fair to both sides, so that although it may be seen as damages for harm to reputation, it is standing in the sense of relations with other people and the way people interact with you. So that's
are the terms used in those specific senses in the Strasbourg case law?
I'll need to come back perhaps with a quote that supports what I'm going to say, but Lord Sumption in Catt cites from, for example, the Pretty case and sets out the concepts of personal autonomy and dignity. One could ask the same question, what's the difference between reputation and dignity? But the Strasbourg language is looking at this concept of autonomy and the harm to a person's standing, dignity, ability to develop relationships, and so on, which are, I accept, closely linked to concepts of reputation, because why is it that you're standing and people are shunning you, other than they think you are not a person they want to be associated with?
I understand that they may all be closely bound together, but for the moment I'm anxious to establish what the difference is, if there is a difference between reputation and standing. For example, Denisov 106, 107 refers repeatedly to reputation.
Yes.
In this case, there was once the claim was amended, there was no claim in respect of damage to reputation.
No.
But was the award of damages of £25,000 intended to include an element in respect of effective standing?
Well,
and if so, what was the difference?
Yes. Well, the answer is there was no claim for reputational harm. Other descriptions were given of the harm that was being compensated. And now I accept that the engagement of Article 8 in the first place is based on, in terms of the privacy tort, is a way of vindicating reputation or protecting against harm to reputation. So, and my answer to my Lord Stevens, which I was going to develop a bit more later on, is you can get damages for harm to reputation in a privacy claim. But the answer to my Lord's question in this case is that it was very clear that we did not seek damages for reputation, and we were not suggesting that the article was false.
Thank you.
I hope that answers your question.
It's not easy for us without assistance, I think, to really grasp the point that's being made in some of the European authorities about this distinction that's drawn in some European legal systems between what seems to be the reputation in the sense of how other people see you,
yes,
and personal integrity in the sense of your own sense of your worth, if you like.
Yes.
And the link, I mean, that sort of distinction hasn't been drawn in our law, but I think, and there's obviously a very close connection, because if you think, why is a person distressed
yes,
if something discreditable about them becomes public? It's because of a sense of shame.
yes,
And shame is a social response
Yes.
to how you think you're going to be viewed by others.
Yes. Well, my Lord, I gratefully adopt that as partly an answer to my Lord Jones's question. Could I, Mr. Mansouri helpfully draws my attention to a section in Mr. Justice Warby's he then was judgment in Sikri, which I think may be of assistance to my Lord on that point he put to me. It's page 1552. And it's probably easy if I just invite the court to read paragraphs 169 and 170. It's under the section reputation. And this is in the section on aggravated damages. And
yes, a clear distinction is drawn there on the lines indicated by my Lord.
Yes, yes, indeed. And again, in Sikri was a case in which Mr. Justice Warby didn't award reputational damages. He awarded £50,000 in general damages for distress, harm, anxiety, and so on.
Thank you.
Thank you.
Yeah, but still, it's a very narrow point. I mean, if you look at the last sentence of paragraph 170, he's saying that these matters, that's other people shunning him,
yes,
and so forth, led to distress and anxiety, and all of this was damage of a kind that was reasonably foreseeable. So, I mean, it's being so you're categorizing the damages by look of things as compensation, not for the fact of being shunned, etc., in itself, but for the distress that causes you.
Yes. Yes. It's looking sort of internally rather than externally.
Yes, yes.
I mean, my...
It's a sort of injury. I mean, it's injury to feelings,
yes,
rather than injury to status.
Yes.
But the two are so connected.
They are so connected, and I accept that. But it seems to me that in terms of a fairness argument or the outflanking argument, the gist of my learned friend's complaint is that this tort is undermining the protection of freedom of expression because it could enable a person to recover damages on a false basis for an unwarranted, unjustified reputation. Now, whatever is the answer to that question, it's not raised by this case, because in this case, it was very specifically clear that we abandoned the argument based on damages for reputational harm, and we did not advance a case based on falsity. And so that complaint of my learned friend simply does not arise on the facts of this case. Part two, then, the developing consensus and the case law. Another way of looking at this is the direction of travel point. Because the argument here is that the direction of travel is all one way and has been now for some years, both in public policy terms and in judicial decision-making. In their article, due soon to be published in the Journal of Media Law, Professor Phillipson and Robert Craig observe, we say rightly, that attitudes to press intrusion to the privacy of suspects in criminal proceedings have undergone a marked change. That is self-evidently correct, and we've set out, I don't take you to it, in our printed case between paragraphs 45 to 55, that's E144 to 147, the various reports, policy statements, official guidance, and so on. The emerging consensus was noted by the lower courts as highly relevant to resolving the Campbell Stage 1 question. See Mr. Justice Nickling at E364 to 367 and the Court of Appeal E212, where Lord Justice Simon referred to the dissenting judgment in Cuja, and he was well aware it was a dissenting judgment, where Lords Kerr and Lord Wilson set out good reasons why a person under arrest but not charged would have a reasonable expectation of privacy in relation to that fact. And the court, I'm sure, is familiar with all of those various documents. The emerging public policy consensus, if that's the right term, about the privacy rights of suspects has been reflected in the case law. Some years ago in PNM, as it was then called, Cuja as it became, Lady Justice Sharp, as she was, acknowledged that was in as long ago as August 2014, Lady Justice Sharp's ruling in PNM. She acknowledged a growing recognition that as a matter of public policy, the identity of those arrested or suspected of a crime should not be released to the public, save in exceptional and clearly defined circumstances. That's page E1200 of the bundle.
It may be that that's a way of addressing the Guardian newspaper's case, that essentially the documents that you're relying on as showing what the current state is of public attitudes and public policy, all post-date that case, and we're responding to developments subsequent to that case.
Yes. Seeking to gauge and then taking into account what most people think is something that judges have done in this field, and in a sense they have to. I mean, Lord Roger in the Guardian News case referred to or said, in allowing this, the law proceeds on the basis that most members of the public understand, etc. And Lord Sumption in Cuja said, experience suggests that as a general rule, the public understand that there's a difference between allegation and proof, and then said, left to myself, I might have been less sanguine than Mr. Justice Tugendhat was about the reaction of the public to the way, so on. And so we say that when applying the Campbell Stage 1 test to the privacy rights of suspects, it is relevant to factor in. I mean, Professors Phillips and Mr. Craig refer to the YouGov poll taken after the Cliff Richard case, which found that 86% of people thought defendants generally should be anonymous while being investigated, 83% that anonymity should remain even after arrest, and 60% thought anonymity should be maintained until conviction. Now, I appreciate this court doesn't usually factor in opinion polls in deciding what the law is, but this is a slightly unusual area here where judges are in deciding what a reasonable person of ordinary sensibilities in the position of the claimant would expect. There has to be some recognition or gauging of the way the wind's blowing and the way the wind has blown. As Mr. Justice Mann observed himself in the Richard case, the question of whether the existence of a police investigation into a person is something in relation to which that individual has a reasonable expectation of privacy had been the subject of judicial assumption and concession in Hannon, that's E1172, in ERY, E3159. And so by the time he came to decide the Richard case, which was the first time that the point had been argued out, he had the benefit at that stage of Mr. Justice Garnham's interlocutory ruling in this case, in which he considered that ZXC would be able to establish that his Article 8 rights were engaged by the publication of the article. Can we just look at what Mr. Justice Garnham said?
Just before we do, I mean, it strikes me that it's not simply a question of whether the general public think there should or shouldn't be anonymity, but whether there is in fact a reasonable expectation of privacy must depend to a large degree on how the police actually behave.
Absolutely.
And, if, for example, there was a culture of the police routinely tipping off journalists of any newsworthy investigations,
Yes.
then that obviously affects whether you can reasonably expect the matter to remain private.
Yeah.
Whereas if, on the other hand, there's the guidance issued by the College of Policing and endorsed by, we know, by various organisations, is to the effect that there should, in general, be anonymity unless there are compelling reasons of policing for not treating the information as private. And that's a major change in behaviour, which is going to influence what you can reasonably expect.
Yes. I mean, one can debate as to who's influenced who, whether the police policy is itself a reflection of its understanding of what they think the public think on this issue. But, my lord, absolutely, I'm grateful to adopt that approach. It's obviously relevant to whether the reasonable person would think this is a category of information that will be kept private, because that's what the police think. Can we just look, again, it's just helpful, Mr. Justice Garnham's interlocutory judgment, because he decides this point pretty clearly, that Article 8's engaged. If you go to E361, sorry, E542, sorry. At paragraph 30, the irony, given the approach that Bloomberg are taking before this court, is that it was Bloomberg who wanted there to be a blanket rule. See, at 30, Mr. Miller submits that in the absence of the sort of concession made by the defendant in ERY, there can't be a reasonable expectation of privacy on the part of a suspect in the information he's being investigated by the police or other state law enforcement agency carrying out its public function. I reject that submission. In my judgment, it's impossible to lay down any such blanket rule in an inquiry as fact-sensitive as this. In fact, I'd go further, as Mr. Owen submits, the right to respect for private life has two core components: unwanted access to private information, unwanted access to or intrusion into one's personal space. And then he goes on to cite from Mr. Justice Tugendhat's judgment, and over the page at the top of 543, in my view, the information extracted from the formal law enforcement document is undoubtedly private, given that no party to it has suggested that they wanted it made public, and its subject, claimant, strongly objects to that happening. He then goes through some case law, and at 34 says, the careful consideration called for by Lady Justice Sharp leads me to identify the following features of the present case as being relevant to the question whether the claimant has a reasonable expectation of privacy. He's a businessman, not a celebrity courting publicity. The formal law enforcement document was highly confidential. The contents of it it seems, been leaked to the defendants in breach of confidence. The article concerns the details of investigation by the law enforcement agency that have not been concluded or made public by the law enforcement agency. The claimant had never been arrested, was not being questioned in a public place. He did not consent to the publication. These features lead me to conclude the claimant would entirely reasonably have expected that the information contained in the formal law enforcement document would remain private, and so on. And so he says the fact he is the subject of the formal law enforcement document is an aspect of the claimant's private life, and he would, in my view, be able to show that his Article 8 rights are engaged by the continued presence on the website. So, by the time Mr. Justice Mann came to decide the Richard case, he had the benefit of that ruling, and he himself then cited, perhaps we just look at that, E1467. Paragraph 246. Perhaps I just invite the court to read 246 and 247. So it's clear from that that Mr. Justice Mann, any more than Mr. Justice Nicklin or the Court of Appeal in this case, was not saying that because publishing the fact of being a suspect is damaging, reputationally damaging, it is therefore private. He was rightly observing that knowledge of the consequences of identifying a person as a suspect was merely one factor, which was relevant to resolving the stage 1 question. It's not determinative. And we say that the approach of Mr. Justice Mann in the Cliff Richard case and the courts in this case is wholly consistent with what Professor Moram, in her 2018 LQR article, Unpacking the Reasonable Expectation of Privacy Test, called the society-focused route to answering the reasonable expectation of privacy. Could your lordships have access to the supplementary bundle at page 40? It's the two articles that we handed in recently.
Yep. And at which page?
It's page 40, supplementary bundle, page 40. Do you see halfway down there should be a heading, the first principle, societal attitudes to the information or information in question?
I seem to have it as a separate document.
Yeah.
We handed it, we put in a PDF, paginated PDF. Sorry. Yeah. It's page 4 within that document. The continuous pagination is
heading Roman 4, the first principle.
Yes, yes.
Page 4 of a separate document, 26 pages.
Yes. It's quite. Could I just invite the court to read that section down to the quote, ending with the quote from Mr. Justice Tipping in the New Zealand case of Hosking?
I'm not sure I've got the right page. It's supplementary 40.
Supplementary bundle 40.
It begins at Roman 4, and the bottom of the page is a citation. Is it from Chief Justice Gleeson?
Yes, that's
right. Okay.
Yes. And it's over to the two paragraphs on the next page as well. And so, two points from that analysis. Firstly, the author herself is agreeing with the concept of starting points when you're looking at a particular activity, and she says at the top of the second page about health information is private. The Court of Appeal in Weller observed the starting point for analysis was where the activity depicted in the photograph happened. The nature of the activity stressed that it was a family activity, which belongs to that part of life protected, and so on. And then the second point, which perhaps comes out clearly from that quote from Mr. Justice Tipping, of the need to factor in contemporary societal values and expectations, and my Lord's point about, well, if the police policy is that all of this remains private until charge, then of course people are going to assume that it's the kind of information that is inherently private. And so Article 8's engaged, then you look at whether there's a reason for that overrides that. Could I invite the court, not now, but we adopt really the whole of part 3 of the Phillips and Craig article on this point. They mount quite a strong attack, we would say, a fair attack on Professor Moram's critique of the lower court's rulings in ZXC, and point out why her analysis about this case is if nothing else, inconsistent with her earlier approach, and seeks to object to the concept of categories of information, or certainly this is a category of information which can ever engage Article 8. But I won't take you to that, but perhaps make clear that we say it's a very helpful analysis of why the Moram approach is wrong.
Could you just give us the bundle reference?
Yes, it's part 3 is in supplementary bundle 11 to 18.
Thank you.
Again, I hadn't taken you to this case before, but could I flagged it up yesterday, perhaps it's appropriate now. One of the points that Professor Phillips and Mr. Craig make is the same point that Mr. Justice Warby had made in Sikri, which is a reference back to the 2009 ruling of the House of Lords in the BBC case. Let me just look at that. It's 2538 bundle. I don't know if the court has looked at this case in pre-reading, but it's a slightly complex case procedurally. This was an attempt by the BBC to lift the anonymity of an individual in the wake of the enactment of the 2003 Criminal Justice Act, which lifted or changed the rule on double jeopardy, so that a person could be prosecuted again, subject to certain strict criteria, including the availability of fresh evidence.
Sorry, Mr. Owen, I don't think I've got the right page.
2538.
2538,
Sorry.
thank you. My fault.
And so what had happened is this individual had been acquitted at his trial for rape because the trial judge had ruled as inadmissible a DNA sample linking him to the premises or the victim. And so he was now an innocent person with the benefit of the presumption of innocence, and effectively, if ever he was going to be charged, he would then have to become a suspect again. The law changes, and the BBC want to write or produce a programme about this case and use the fact of the DNA sample and the circumstances in which the House of Lords had said it was wrong to exclude this evidence altogether, that it was potentially admissible as a matter of discretion. And so the question was, should his name be revealed in this programme on the basis of the available DNA evidence, now that he could be prosecuted for a second time? And the importance, if we go to 2557, Lord Hope at paragraph 22 says this: as the indiscriminate retention of samples of a person's DNA must now be held to be incompatible with his rights under Article 8.1, so too must be the publication of the fact that his retained DNA has been used to link him to the commission of a crime of which he's been acquitted. I think it must follow that the test as to whether this information in respect of which D had a reasonable expectation of privacy is satisfied. He was acquitted of the burglary in connection with his DNA samples were taken. He'd been acquitted of the rape too. The double jeopardy rule has been abolished, but the Attorney General has not taken steps to seek his retrial for that offence. He remains entitled to the presumption of innocence. This is not just an Article 6 point, as the direct bearing on the approach that must be taken to his Article 8 right. The link that his DNA sample provides to the commission of the rape his personal information, the giving of publicity to the link will inevitably suggest he's guilty of the offence. Lord Panic described it as the jigsaw effect. His reputation, his personality, the umbrella that protects his personal space from intrusion will just as inevitably be damaged by it. The conclusion that broadcasting this information will engage his right to respect for his private life seems to me to be inescapable. And so that's why Mr. Justice Warby and Phillipson and Craig refer or rely on this ruling as having established or held that this category of information, here information that would be argued shows he is a suspect of a crime at a stage before he's been charged, undoubtedly engages his respect for private life. The question, and it was answered against the individual in this case, is that there's a justification for publishing it. We also rely in this area on what Lord Sumption said in Cat. I won't take you back to it. He cited from the PG and UK case. As we also rely on Mr. Justice Warby's reference in SICRI to data protection law, and the fact that for 25 years it has classified personal data relating to the alleged commission by a data subject of any offence as sensitive personal data or special category personal data, the processing of which requires additional justification. And at Supplementary Bundle 18 to 19, Phillipson and Craig say this at the conclusion of their review of this section 3 of their article. They say it's desirable for Article 8, English common law, and the conception of personal data used in the UK's data protection regime based on EU law to retain at least a basic overall harmony. Professor Moram's approach would splinter it into incoherence. And to that linking of Article 8, English common law, data protection, EU law, and so on, I add freedom of information law, the point I'd made earlier on. It's sections 30 and 31 of the Freedom of Information Act 2000, which would mean that information held by a public authority is exempt if it has at any time been held by the authority for the purpose of any investigation which the public authority has a duty to conduct with a view to it being ascertained whether a person should be charged with an offence. So as a matter of category, that is exempt from Freedom of Information Act.
I mean, it may be worth perhaps bearing in mind that, if I remember correctly, Professor Moram is a New Zealand academic.
Yes.
I think the University of Wellington.
Yes.
And there, I mean, they may well adopt the tort, which the common law has adopted, but they won't have any reason to align it with EU law or the ECHR.
Well, that's true, yes. It may also be, we try to look into it to see what the policy of the police is in New Zealand, yes, as to whether it's aligned exactly with the College of Policing guidance here. It's not quite clear whether they have as clear a policy as we do here, but we're obviously focused on here. So, Lord, that's part 2, the direction of travel point. Part 3, and some of these points I've already flagged up, so I won't take as much time as I'd originally planned, but this is part 3. This is rebutting the 5-pronged attack on the lower courts. And the first of these is what I've called the presumption of innocence issue, and I've really anticipated some of this, so I won't hopefully repeat myself. For your note, we address this argument at paragraph 61 to 72 of our printed case at 149 to 154. And Professor Phillipson and Robert Craig addressed the issue in part 5 of their article, and that is at page supplementary bundle 24 to 35. A short point, as you know, that we make about the suggested inconsistency between the approach of the Court of Appeal in this case and the approach of this court in Cuja is that there is no inconsistency. Cuja was a case decided on the basis of the open justice principle. And the issue which divided Lords Kerr and Wilson from the majority was whether Mr. Cuja could establish a reasonable expectation of privacy in relation to the reporting of matters discussed extensively in open court, including in evidence given by witnesses and in submissions made by Mr. Cuja's own counsel, having omitted even to attempt to secure anonymity prior to the trial commencing. And the references for your note, I won't take you to it, to the type of evidence that had been given is paragraph 4 of Lord Sumption at electronic 1414, 6 and 7, 4, 6 and 7, pages 1414 to 1415, where he describes what had happened in effect at the trial. In other words, it was a case where the cat was well and truly out of the bag, and it would have been flatly inconsistent with the open justice principle to try and stuff it back in. And that fact in itself destroyed any attempt to argue that Article 8 was engaged by the decision to lift PNM, as he then was, his anonymity. Can we just look again at what Lord Sumption said? It's at E1430.
So what was the page number, please?
E1430, my lord. So at paragraph 34, subparagraph 3, do you see it at H? This paragraph, he's dealing with the impact on PNM's family life. But at H, Lord Sumption said this: a party is entitled to invoke the right of privacy to protect his reputation. But as I've explained, there is no reasonable expectation of privacy in relation to proceedings in open court. If we go to paragraph 1334 at 1416.
Sorry, the reference again, please.
I'm not sure if I've given you the right one. Hang on a second. Which page is that? Sorry, it's 34 sub 1. Yes.
Same page.
So, I'm so sorry.
1430.
1430. Yes. So here, Mr. Justice Tugan had committed no error of law, says Lord Sumption, and his conclusion was one he was entitled to reach. Left to myself, I might have been less sanguine than he was about the reaction of the public to the way in which PNM featured in the trial. That would have made no difference. PNM's application is not the trial should be conducted so as to withhold his identity. If it had been, the considerations urged by Lords Kerr and Lord Wilson in their judgments in this case might have had considerable force. Moreover, Lord Sumption, as we know, speaking for the majority, said there's no general presumption of law that the public understand the difference between suspicion of guilt and guilt. And if we go to paragraph 8 of Lord Sumption's judgment, which is page 1415, sorry. The final sentence, it's a passage you've already looked at. That final sentence, in my opinion, the present appeal must be approached on the footing that there's a real risk that a person knowing of these matters would conclude that PNM had sexually abused the complainant, notwithstanding he'd never been charged with an offence. We say that that's an important point that he's making, and it means that Bloomberg's case is wrong insofar as it proceeds on the basis that Lord Rogers' statement in Guardian News and Media does operate as a legal presumption. The majority in Cuja held that it does not. And we would suggest that the final sentence in paragraph 8 of Lord Sumption's judgment in Cuja plainly can apply in a wide variety of cases, so that the factual premise that the public may assume no smoke without fire, and the fire here not necessarily meaning guilt, but good reason to suspect, justifiable investigation, and so on. The factual premise that the public may assume no smoke without fire from the fact of a person being a suspect in a state investigation is a relevant consideration in all MOPI claims when addressing the Stage 1 Campbell question. Bloomberg assert in paragraph 12 of their case that the reasoning of the Court of Appeal at E246, 248, at paragraph 60 to 61, is based to a significant extent on the dissenting judgment in Cuja. But at paragraph 61, the Court of Appeal merely said that the references in the minority judgment in Cuja to irremediable damage and the most dreadful unhappiness and distress give support for a general expectation of privacy in relation to those who've been arrested. And given that the effect on the claimant is one of the Murray factors, we say it's impossible to understand why the Court of Appeal were wrong to take into account the points made by Lords Kerr and Wilson in Cuja, which, as I've explained, Lord Sumption said would have had considerable force in his case were it not for the fact that the cat was already out of the bag. Now, the cat is not out of the bag here, and ZXC is in a completely different position from Mr. Cuja. He's not been named in any criminal public proceedings. He's not even been arrested, still less charged. He's always been anonymized in these civil proceedings. And the Court of Appeal were doing no more than stating the obvious fact that the damage, unhappiness, and distress caused by publishing the fact that he's a suspect under investigation is a clear reason why a person would want to maintain privacy in relation to that information. So, in other words, the capacity of the information to cause enormous distress, unhappiness, irremediable damage is highly relevant to the assessment of whether there's a reasonable expectation of privacy under the Campbell and Murray test. As for the suggested clash between the approach in defamation law, Mr. White referred you to the defamation case law, that the ordinary reasonable reader is not unduly suspicious or avid for scandal and can distinguish suspicion or investigation from guilt. He says there's a clash between that approach in defamation law and the Court of Appeal's reference in this case to the human characteristic to equate suspicion or investigation with guilt on the assumption that there's no smoke without fire. We say that that's based on a misunderstanding of the Court of Appeal's approach. We set out our arguments. I won't obviously take you to it, but it's in our case at paragraph 66 to 72. The 3 points we make there are as follows. Lord Justice Simon merely said that the public would not assume innocence, not that they would assume guilt. And there is a difference. This reality is acknowledged in the law of defamation. Publishing a statement that a person is under investigation is defamatory. See Lord Devlin in Lewis and the Daily Telegraph, and see also Mr. Justice Warby, as he then was, in Mia and the BBC. An allegation that you're under investigation is considered defamatory because it implies grounds for investigation or suspicion of guilt. Secondly, there is a clear distinction between a reader's knowledge that the law presumes innocence until proven guilty and a reader's own belief and perception of probable guilt. That's the point that Lord Kerr and Lord Wilson make in Cuja. And the Court of Appeal's reference to the human instinct to assume no smoke without fire is both consistent with defamation law and common sense reflection of the tendency to assume without any other evidence that there is a sound basis for the investigation. Thirdly, my own friend Mr. White suggested that the Court of Appeal diverges with the approach taken in defamation cases and the ability of ordinary reasonable readers to distinguish between suspicion and guilt. However, as we point out, the defamation law concept of the ordinary reasonable reader is a feature of the single meaning rule. That is a sui generis law of defamation which has been much criticised. I won't take you to it, but Lord Justice Sedley, in the Ajinomoto case, between paragraphs 26 and 35, E2618, sets out very comprehensively and strongly what the criticisms of that law are, and results in the Court of Appeal allowing the appeal and refusing to apply the single meaning rule to the tort of malicious falsehood. My own friend suggested that we are wrong in our case to say that the single meaning rule does not apply to any other speech or publication-based tort on the basis of the Trimmingham case. But we do say with respect that's misconceived. Mr. Justice Tugendhat in that case did not say the single meaning rule should apply when determining a harassment by speech case. He simply stated that in such cases, the court may have to decide what meaning the words convey. And in deciding that, the court should put itself in the position of the reasonable person. But the test he applied was expressly noted to be different from that to be applied in defamation. And you see that, I won't take you to it now, but it's paragraphs 57 and 58 of Trimmingham on page E2741. We respectfully adopt, as I've indicated, the criticism of Professor Phillipson and Robert Craig, where they criticized Professor Morum in terms of her approach to the outcome in ZXC on the basis it comes perilously close to inviting the courts to disregard the presumption of innocence. The section of her 2019 article, which is in the bundle, headed, the subheading is "Should Evidence of Wrongdoing Be Private?" That's at E1820. Again, I'm not going to take you to it, but that's the section in which she really makes what I suggest is a rather extraordinary analysis. She argues, in effect, that the media should be entitled to name suspects before charge in case claimants are found guilty, and on the basis that the courts will assume that whenever the police are investigating a suspect, there'll be some reason to think that he or she is guilty of an offence, so that suppressing the fact that someone is being investigated prevents the public from hearing about possible wrongdoing. Now, that, with respect to Professor Morum, is to turn the presumption of innocence on its head. As Phillipson and Craig argue, recognition of a general rule in favour of privacy in relation to being a suspect under investigation reflects a decision to act compatibly with the presumption of innocence, subject always, of course, to the balancing exercise and the fact there may be a public interest justification in an individual case. Second of the 5 prongs, the reputational harm issue and whether the activity was of a nature as to fall within the scope of ZXC's private life. Lord, I've made the point already that Bloomberg was wrong insofar as they assert that the lower courts were influenced to find a general rule of a reasonable expectation of privacy based solely on a concern to protect a suspect from unwarranted reputational damage. And I've shown you what Lord Sumption said. paragraph 21 at E1421, protection of reputation is the primary function of the law of defamation, but although the ambit of the right of privacy is wider, it provides an alternative means of protecting reputation, which is available even when the matters published are true. And again, his quote, a party is entitled to invoke the right to privacy to protect his reputation. And so we say that the suggestion that the MOPI tort can't be used as an alternative to defamation to protect a claimant's reputation is untenable. The tort is expressly conceived of as a vehicle for protecting Article 8 rights, and as Cuja itself demonstrates, the UK courts have expressly accepted that reputation is an aspect of Article 8. We do accept that there may be cases in which a claimant may plead the misuse of private information tort on the basis that the nub of the claim is damage to reputation and thereby seeks to avoid the rules which govern defamation claims. Such a claim is liable to be struck out as an abuse. And my Lord Stevens was presided in a case called Cushnan against the BBC, that's E3223, where a claimant sued the BBC over a programme which it was argued said he was corrupt or suspected of corruption. And he sued on the basis that the programme would be a contempt of court, that he was entitled to an interlocutory injunction on the basis of a misuse of private information and under the Protection from Harassment Act. In that case, the claimant had defined the subject matter of his complaint in relation to which he had a reasonable expectation of privacy as his enduring reputation as a man of good character, honour and integrity. And counsel for the claimant expressly disavowed the information in relation to which he had a reasonable expectation was that he'd committed or that he was suspected of having committed offences. And my Lord Stevens rightly observed that the tort of defamation protects good character, honour and integrity. In the tort of MOPI, it is not sufficient to just identify what is protected in the tort of defamation. In the absence of an occasion of privacy, that part of the claim is not sustainable and is an abuse of the court's process, and the MOPI claim was struck out on those facts. But here, as we sought to make clear, ZXC has identified, to use Lord Stevens' words, an occasion of privacy. In other words, the true fact of being under investigation and suspected of various crimes by the UKLEB. That's the private information in issue.
But as a matter of principle, torts aren't mutually exclusive. It's perfectly possible for a given set of facts to give rise to a cause of action in more than one tort.
Yes.
In malicious prosecution of a civil claim or malicious falsehood are going to overlap quite considerably with defamation.
Yeah.
You give some examples. So it's really, you have to decide what the proper scope is of a tort, but the fact that it overlaps with another tort isn't in itself, I thought, a very persuasive objection.
No, I respectfully agree. But you have to establish the elements of the tort, and here you have to establish an occasion of privacy, to use my Lord Stevens' description in Cushnan, and we have. Third prong of the attack, which I deal with again briefly. This is the argument that the lower courts took no sufficient account of ZXC's status and failed to distinguish between information which merely damages reputation and information which undermines personal integrity. We deal with this objection at paragraphs 92 to 95 of our case. That's E163 to 165. and explain why we say that Bloomberg's reliance on the domestic case of Lord Brown and the Strasbourg cases of Al-Fayed and Steele and Morris are misconceived. And we make the specific point in footnote 28 that Bloomberg's case is wrong in saying that Lord Brown was not a director of BP. In fact, he was the CEO and a member of the board. But we emphasize in this area that the status of the respondent is a fact-sensitive question, and both the judge and the Court of Appeal expressly noted that ZXC held a senior position in X Limited Company, but he was not a director and achieved no particular prominence in his role. And that is recorded in the SFI at E59, paragraph 3, subparagraph B. In relation to the status issue, and this is not cited in our case, but it's quite a helpful passage. It's a judgment of Mr. Justice Briggs, as he then was, in the 2013 case Rock and Roll against News Group Newspapers. It's E2838. And now I need to find the right passage. Let me just find the quote passage. I'll get you the precise 15 passage. Is it 15? Thank you very much. Sorry. Yes, thank you very much. Yes, it's E2844. Paragraph 15. Just to set it in context, the claimant was the husband of the actress Kate Winslet, and he sued over the publication of embarrassing pictures taken of him at a private party. And at 15, Mr. Justice Briggs then dealt with the argument that because of C's former employment with Virgin Galactic, which was owned by his uncle, Sir Richard Branson, he was a public figure. Taking these points separately, the claimant's employment with Virgin Galactic comes nowhere to placing him in that narrow category of persons who, although engaged in no public office, may be regarded as having reduced expectations of privacy due to their important role in national affairs. They may include the chairman of major public companies and the captains of national sporting teams, but the claimant was, so far as the evidence goes at this stage, no more than a not very conspicuous middle manager in his uncle's private business empire. In any event, that role ceased some 2 years ago. So it's just an illustration of status and its relevance. It is but one factor in the mix. It may be enough to tip the balance, but the point is it is a fact-sensitive exercise, and the courts below concluded that the respondent was not the kind of person, for example, that Mr. Justice Briggs is describing there, who although not not holding public office, has got some other status which is relevant. And as for the argument that the Court of Appeal failed to take into account the distinction between information which merely damages reputation and information which undermines personal integrity, and the requirement of prejudice to personal enjoyment of the right to respect for private life drawn from Axel Springer, we say that is equally devoid of merit. See paragraph 95 of our case at E164. As I've indicated, the judge expressly held that publication had never negatively impacted ZXC's dignity and standing, caused him significant distress and anger, and had a negative effect on his family life. As he observed, the evidence about the impact of publication on him was not challenged at trial. And as we know, he disavowed a claim for compensation for reputational damage. He wasn't awarded a remedy for mere reputational damage. And there's never been an appeal there was no appeal against the award of £25,000. And so the idea that this didn't the harm or damage that was found was trivial and didn't go over some threshold of seriousness is in my submission, impossible. No point looking at the witness statements of ZXC and his wife and saying, well, that doesn't look very serious. So evidentially, it did not pass the threshold. The fact is, it resulted in an award of £25,000 in damages. As I say, the main remedy that the claimant was concerned about was the injunction to require the article to be taken down. The fourth prong of the five-pronged attack is the artificial distinction issue. And again, I've dealt with this really already. We deal with it, for your note, at paragraphs 96 to 101 of our case. That's E165 to 167. And I've made the point of the distinction between the conduct and the suspicions of the UK LEB. There's an obvious difference between that. I come, fifthly, in this heading, to the outflanking issue. I can't resist making the observation of my learned friend, Mr. White, who was junior counsel for Miss Naomi Campbell, and established the Moppy tort. There is a certain irony in him, 17 years later, complaining that this youthful tort is now shaking the foundations of the mature tort of defamation. The fact is, they are separate torts, as my Lord Reed has said, and there's clear authority that one does not import the defamation law principles uniquely as they have been developed into other speech torts. Our response on this outflanking issue is at paragraphs 102 to 108 of our case. I haven't got references for that. And as I say, we also, sorry? Yes, 167, electronic 167 to 170, thank you. And we also gratefully adopt the Phillips and Craig critique of Professor Moore in section 5 of their article. We don't, however, adopt, obviously in this case, on the basis of what they say, the suggestion that one way of dealing with the problem of awarding damages for an unwarranted reputation or awarding damages on a false basis would be that you postpone hearings for damages until the conclusion of criminal proceedings, or that you have a creative escrow solution fashioned to ensure that damages are not left in the hands of a person subsequently convicted. I mean, the main point about our claim, as already said, is that the nub of his claim is not the protection of reputation. He didn't advance a claim on falsity, didn't contend the article meant he was guilty of any offences of fraud or bribery. His objection was to the publication of the true facts.
And what about in other cases?
I'm sorry?
In other cases, what do you say the approach should be?
Well, my primary answer is this, that where a person is bringing a privacy claim in respect of the harm caused to him by the release of the information that he is a suspect, he is awarded damages for that wrong. And if he is not claiming, as ZXC is not, reputational damage, there isn't a problem. If a person is seeking to claim damages for harm to reputation and alleging that the allegation is untrue, then of course a media organisation has got to be entitled to defend the claim on the basis that it is true. I mean, the reality is that most suspects, the last thing they're going to want to do is litigate the issue in a civil court before they're tried in a criminal court. So as a matter of practicality, I can't see it ever likely to arise.
What should happen about interim relief in those circumstances? If there is a claim based on misuse of private information,
yes,
and a claim which includes effect on reputation, damage to reputation,
yes, Do you mean interim relief in the form of an injunction?
Interim relief in the form of an injunction, because in defamation, as I understand it, the usual position
Yes.
of Madam Perriman is that
Yes.
if justification is pleaded, then there can't be an interim relief.
But the ultimate justification is that if you are arguing that something is private, once it's released, if you don't get the interim relief, you've lost the privacy. So the entire purpose of the action is defeated right at the outset. And so my submission is that if you succeed in showing that this is private information, the law is protecting that private information, and that's the right approach. So there isn't a conflict in my submission.
Say the same about Bonnet and Perriman. As soon as the matter is published, you've lost your reputation.
Yes, but there is a different principle in play there, that if you're going to justify it as true, then the media organisation runs the risk that if they can't do that, they will have to pay heavy damages. But it's in any event, I say there is not a conflict there between.
Thank you.
The two torts. Can I just set out in a bit more detail, because my Lord indicated that the case is here and the court may want to say something about the question of whether reputational damages can ever be awarded in a MOPI claim in light of what Mr. Justice Warby had said in Sikri. And there is a difference between what he said in Sikri and what the judge said in our case, and indeed the approach of Mr. Justice Mann in the Richard case. My learned friend said at one point that we had conceded that the facts were not false, which could have suggested that we accepted that the facts were true. And to the extent that that was the suggestion, as I said, that's not the position. My learned friend took you to the order of Mr. Justice J at the PTR. And at that stage, we agreed to remove the passages in the particulars of claim which referred to the allegation being believed to be true, and expressly agreed that for the purposes of the trial, he did not contend that the December article meant or alleged he was guilty of any of the criminal offences referred to, and that the claimant was not advancing a case on falsity. And so firstly, we only made, if you like, a concession relating to a removal of the suggestion of guilt. The claim that ZXC was suspected of criminal offences by the UK LEB remained. And secondly, it was not accepted that the allegations were true, merely that he was not suggesting that they were false. And thus, the truth or falsity of the underlying information was expressly not in issue. And that is accurately, with respect, recorded in paragraph 152 of Mr. Justice Nicklin's judgment, that's E379, where he said, in this case, the claimant made an express concession that the truth or falsity of the underlying information in the LOI is not a relevant issue. In my judgment, the consequence of that is, whilst he can legitimately rely upon the distress and embarrassment that he's felt as a result of the publication of the information, he cannot be awarded any element of purely reputational damages. Mr. White suggested that you could obtain damages in privacy cases for non-reputational impact, undermining of personal integrity, distress, but you can't award it for injury to reputation. And he referred to ZXC and Sikri and stated that we accept those two cases are rightly decided on the question of damages. But that is with respect to ignore our primary position and to conflate different issues. Our primary position is that damages are not in issue in this case on appeal. Sorry, not in issue in this case because of the way the case was presented, and no reputational damages claimed and none awarded. To that extent, therefore, it's not an issue relevant to the facts of this case. And secondly, to the extent it was suggested that Sikri and ZXC approached the question of damages on the same basis, and both stated that damages for injury to reputation could not be claimed in a MOPI claim, it's simply not accepted. the approaches were not the same. And importantly, in Richards, Mr. Justice Mann determined that reputational damages could be awarded in a MOPI claim, and he made such an award to Sir Cliff Richard. In this case, my Lord, Mr. Justice Nicklin did not say they could never be awarded, rather that a defendant would have to be permitted to defend as true any underlying defamatory allegations that fall within the claim for misuse of private information, or advance any other defence that would have been available had the claim been brought in defamation. He said that at paragraph 150, Roman 3, that's E378.
Can you give us the reference in the Richards case?
Yes, I'm going to, in fact, take you to that. It's E1486. At paragraph 334.
Sorry, page again?
Page 1486. So at 334, he said, Sir Cliff's claim has various elements. I consider them so far as relevant below, but I start with the question of reputation. Mr. Miller had submitted, insofar as Sir Cliff's claim was based on damage to reputation, that could not be the subject of a privacy claim. Loss of reputation was the sole province of defamation. It's true that to a significant degree the adverse effect on Sir Cliff was damage to his reputation, though that is not the essence of a privacy claim. It is not the sole basis on which damages can be claimed. Nonetheless, some damage to reputation is inherent in the facts of the present case and can fairly be seen as being part of the reason why Sir Cliff felt it necessary to lower his public profile after the search. I therefore need to consider whether Mr. Miller's submission is correct, because if and insofar as it is, then Sir Cliff's damages claim would have to be abated. He then, at 343, on page 1488, he refers to Kuja. The case law, that case law does not support Mr. Miller. In fact, recent case law points the other way. In Kuja, the preponderance of speeches acknowledged that the protection of reputation was part of the function of the law of privacy. And then he quotes from Lord Sumption, I won't read that. And so it follows that there's nothing implicit about what Lord Sumption said in Kuja. Lord Sumption's pronouncements were explicit. He was expressing his own views on the protection of reputation and approving Mr. Justice Tugendhat's views on the same point. And in Sikri, Mr. Justice Warby took a different approach. If you go to E1551, para 163, I can't remember if Mr. White took you to this yesterday, but he said, the reasons I've given, I would, if necessary, hold that damages for injury to reputation are not available in a claim for misuse of private information. A claimant who wishes to recover such damages must sue in defamation on one of the other torts in which it is established that reputational harm is compensatable. These conclusions are not inconsistent with Avon, where the claim was in data protection. I do not consider them to be at odds with the decision in Richard either. On the face of it, Sir Cliff would have had an unanswerable claim in libel. The arguments in this case have been different from those considered and rejected by Mr. Justice Mann, and my reasons invoke distinct considerations. But if and to the extent that my conclusion is contrary to the reasoning of Mr. Justice Mann, I must respectfully disagree. The point was the BBC did not seek in that case to suggest that there was any truth in the allegation that was being investigated against Sir Cliff. But there clearly is a difference, to some extent, between the approach of Mr. Justice Warby in Sikri and the approach that Mr. Justice Mann took And I've said this issue, we say, doesn't impact on this case and this appeal. But to the extent that the court was minded to consider the issue, we would respectfully submit that reputational damages should be available in some circumstances in a privacy claim. And that's because protection of reputation is part of the function of the law of privacy, and it's therefore illogical not to allow claimants in appropriate circumstances to seek a remedy. And what Mr. Justice Mann said in Richard is an example of where it's appropriate, and my Lord Reed's example of the TV presenter yesterday is another example of where it would be unjust to prevent the recovery of reputational damages in a MOPI claim. As far as reputation is concerned, the damages would be to compensate the claimant for the fact that private information was published at a time when it should not have been, and thereby caused reputational damage. It would not be to vindicate their reputation and to make an award to demonstrate to the world that the allegation was false, which is one of the purposes of the award of damages in defamation. If a claimant in a MOPI claim did suggest that the underlying allegation was untrue, then we accept a defendant would need to be able to rely on the defences of truth as well as public interest. And that's what Mr. Justice Nicklin says at paragraph 150, Romans 3. But that wouldn't arise in all cases, and it wouldn't, we suggest, throw the law into chaos, as Mr. White suggests. And Richard is a good example of a case where there would not have been any defence of truth or public interest for the reasons that Mr. Justice Warby stated in his judgment. On the face of it, Sir Cliff would have had an unanswerable claim in libel. And so...
And why shouldn't it be an award to vindicate reputation?
I'm sorry?
Why shouldn't it be an award to vindicate reputation? In a misuse of private information case?
My Lord, as a matter of principle, as I've said, there is no objection to that. The concern is that you would bring a MOPI claim and seek to treat it as if it is a defamation claim without allowing a defendant the same opportunity as he would have in a defamation claim to justify it as true. As I say, that's not this case.
It's quite tricky because you can have, clearly there can be private information which you're very anxious to keep private precisely because it is true. Yeah. And the right to be forgotten case is an obvious example where the disclosure of a fact that perhaps you had been convicted 30 years earlier of some offence might well be both might well have an impact on your reputation amongst other things, but the truth of the information would be no defence.
Yeah. Well, no. So it would depend entirely. The right to be forgotten cases and the impact of the Rehabilitation of Offenders Act, which is a statement of the ability of a person to put their past behind them, would mean that, yes, I accept in those cases there would be nothing offensive about awarding damages for damage to reputation.
Well, I mean, a lot of in defamation, some of the thinking is along the lines that if you have a reputation which is undeserved, you shouldn't receive compensation for, as it were, being cut down to your proper size.
Yes.
But if you're looking at this in terms of privacy, then if, for example, some prominent person is having an extramarital affair, the disclosure of that may diminish his or her reputation. But why should... I'm just thinking aloud. Does that mean to say that the damages should be diminished?
My lord, no, I would say...
I mean, the wrong lies in the disclosure of something that should have been private.
My lord, yes, I accept that. And that's why I suggest that Mr. Justice Warby's statement goes too far.
But also, I mean, I can't really see why then the damages aren't to a degree to vindicate the reputation, because the point of the objection is that the reputation should not have been harmed.
Yes. The problem arises, I accept, in a criminal conduct case where there is a chance that the matter may yet be proved. And the concern in those cases is that you succeed if you advance a case that the allegation, not only should it not have been reported because it was private, but it's also untrue, the allegation, and then the media are not entitled to defend the claim on the basis, well, actually it is true, then I can see that would result in a situation where a person might be seen ultimately to have got damages on a false basis, in one sense. The argument would be that, yes, you sought to protect your privacy because, and you're right, it was private, but in fact it's then shown to be true. It wouldn't be right for you to get full damages on the basis that you were innocent as charged. But that isn't the problem in this case. And as I say, in most cases, a person who brings proceedings while they are a suspect isn't going to want to litigate the matter in a civil claim and seek to sort of establish their innocence in the context.
Quite as sanguine about that as you are.
Well,
I can imagine lots of people wishing to do it.
Well, one should never say never, I accept. But my general response to the points that are being put.
They might do it for a tactical reason, to see what the evidence was, and so on. You know, there would be lots of ways of playing that out.
Yes, but if you chose to do that, you would run very high risk that in fact you end up being shown to be guilty in the civil proceedings. But
I mean, in the reasoning of I think it's Mr. Justice Mann is if I may say so, strikes me as logical that if you're seeking damages on the footing, on the basis that what has been printed or published is untrue,
yes,
then just as a matter of justice, evidently the media must be able to lead evidence to the effect that it is true.
Yeah.
But one wouldn't. But I'm just sort of hesitating at the idea that you are necessarily, well, you wouldn't typically in an MPI case be seeking damages on the basis that what had been said was untrue. The nub of a complaint is that it's private.
Is that it's private,
regardless of whether it's true or false.
Absolutely, and that was absolutely our approach here. Truth and falsity was irrelevant. It's private. It should not have been published. It should be taken down. There's no public interest in publishing it.
I wonder if you could deal with it, I don't know, on the basis of a contingency, because in a sense, if someone is identified as being a suspect in a criminal investigation, and that involves, at that stage, unwarranted impact on their reputation, standing, however you want to put it, such that they should get compensation for how it's affected them then. But later, they may be charged, they may be found to be guilty. But obviously, at that later point, other reasons have intervened as to why they might be shunned in society or whatever.
Yes.
I mean, sorry, I'm just speaking aloud. Whether one would somehow qualify the damages available insofar as it goes to reputation in relation to breach of privacy against the possibility that there might be, they might be found guilty later. I don't know, but that sounds quite difficult as well, because how is the court supposed to speculate without damaging their reputation even more?
I mean, and this is not a problem that is confined to MOPI. I mean, it's in public record, the author, Geoffrey Archer, he won a libel claim on the basis of the allegation that he behaved disgracefully, but he was then prosecuted and convicted, and I think he had to give the libel damages back.
Yes, and if he hadn't given them back, I suppose there would have been a restitutionary claim for their recovery.
Yes, could well have been. Yes, well, I think there was I think that was what was threatened, and I think in the context.
Yes, from memory, wasn't there a claim at least intimated that the judgment was obtained on the basis of fraud, which in itself is a cause of action.
And the cyclist Lance Armstrong, he sued the Sunday Times, I believe, for saying he was a doper and had doped himself while doing the Tour de France. And then, of course, he confessed on the Oprah Winfrey show that is true.
But I mean, that's not going to be a solution to this sort of problem, is it? Because
no,
the person coming forward with the breach of privacy claim doesn't have to maintain it's all untrue.
No.
And so they won't get their judgment on the basis of fraudulent statements by them.
No. The only problem that arises, and I confess I'm not able to provide my Lord Sells with a perfect solution to that question, because my premise is this is not that case. This is not the case which creates this problem at all because of the way it was presented and the basis on which damages were awarded. But as a matter of principle, our answer in response to the points the courts have raised are, for all the reasons that have been raised or flagged up, as a matter of principle, it should be possible to obtain reputational damages in a privacy claim. And there are numerous examples of why that would be right in principle and not unfair to a defendant, because the defendant is deprived of a particular defense. Where the claimant in certain category of cases is arguing the case beyond the argument, I'm entitled to damages because this is private, and goes on to say it's also not true, then at that stage the court may have a difficult task in calibrating precisely the basis on which damages. I would suggest that at the time of the award of damages, it's hard to do anything more than to assess whatever evidence is before the court about whether the conduct is not private, but it's also true, and award damages accordingly. And then it may be that subsequently there'd have to be.
I mean, that sounds like the worst of all worlds, doesn't it? If you're saying that the court should do its best, well, in the proceedings, I mean that will potentially imperil later criminal proceedings.
I can't see how it couldn't make any difference to subsequent criminal proceedings, because there could be different evidence, and once a charge is being brought, it would have to be tried by a jury. As I say, I accept my Lord Stevens says to me that one should never exclude the possibility of a person for tactical reasons. But as I say, that you run great risks there, because once you're arguing the truth is directly relevant, the obligations of disclosure are completely different. You're required to disclose everything in your possession that's relevant to the issue of your guilt at the very time that you're under investigation. So again, I suggest that you'd be running a high risk, but I mean, I agree that it's impossible to anticipate and imagine all the different circumstances which may arise. But for present purposes, my submission is that the approach of Mr. Justice Nicklin on the damages question in this case is perfectly correct, albeit that the issue we're now addressing does not arise on the basis of the way this case was litigated. My Lord, that completes part 3, and I think the remainder of what I've got to say can be very short. I should therefore be finishing before lunchtime. Part 4 is really the issue 2 question. Did the lower court wrongly conflate confidential information with private information, thereby tainting their approach to both stages 1 and 2 of the Campbell test. And we address this issue, we address issue 2 in paragraphs 109 to 138 of our case at E171 to 179. And we gratefully adopt, again, the analysis in Professor Phillipson and Robert Craig's article, part 4, and that is supplementary bundle 20 to 25. Sorry, 19 to 24. This is the section in their article that says, are such cases really only about breach of confidence? Our main point is that my own friend is really tilting at windmills. The court below were well aware of the conceptual distinction between confidentiality and privacy. As Professor Phillipson and Mr. Craig rightly observe, the fact that confidentiality is no longer a necessary factor for privacy to be protected emphatically does not mean that it's somehow become irrelevant, still less an obstacle. There will be numerous examples, they say, in which privacy and confidentiality go hand in hand, and that's at page 23 to 24. Indeed, the implicit premise of Bloomberg's case that privacy and confidentiality are mutually exclusive, or at best only rarely overlap, is inconsistent with the fact that the tort of misuse of private information had its juridical roots in the wrong of breach of confidence. And neither Mr. Justice Nicklin nor the Court of Appeal ruled that the mere fact that the information was confidential meant that it was private. The nature of the information and its source was simply one, as I say, albeit the most significant factor, which supported the conclusion that ZXC had a reasonable expectation of privacy. And we set out at paragraphs 110 to 112 of our case the references in the lower court's judgments which make that clear. At para 116 of our case at E172, we cite the case law on the sensitivity of letters of request to demonstrate why the courts were bound to regard the information in issue as especially confidential. And I've made the point it was a live investigation and so on. In relation to the stage 1 question, the case law is clear that the concepts of privacy and confidentiality are now closely aligned. The law no longer looks at confidentiality in the context of the traditional situations which generate an obligation of confidence. And so in Campbell itself, Lord Nichols explained, perhaps we can just look at what Lord Nichols said in Campbell. It's at E952. At 14, Lord Nichols said, this cause of action has now firmly shaken off the limiting constraint of the need for an initial confidential relationship. In doing so, it has changed its nature. In this country, this development was recognised clearly in the judgment of Lord Gough in the Guardian newspaper's case. Now the law imposes a duty of confidence whenever a person receives information he knows or ought to know is fairly and reasonably to be regarded as confidential. Even this formulation is awkward. The continuing use of the phrase duty of confidence and the description of the information as confidential is not altogether comfortable. Information about an individual's private life would not in ordinary usage be called confidential. The more natural description today is that such information is private. The essence of the tort is better encapsulated now as misuse of private information. And at 15, it goes on, in the case of individuals, this tort, however labelled, affords respect for one aspect of an individual's privacy. That is the value underlying this cause of action. an individual's privacy can be invaded in ways not involving publication of information. Strip searches are an example. The extent to which the common law as developed thus far in this country protects other forms of invasion of privacy is not a matter arising in the present case. It doesn't arise because although pleaded more widely, Ms. Campbell's common law claim was throughout presented in court exclusively on the basis of breach of confidence. That is the wrongful publication by the Mirror of private information. And so the tort has developed from breach of confidence, but is now accepted to be wider, and in addition encompasses situations where there is no longer any confidential information. See, for example, Mr. Justice Warbeatty then was in SICRI E1528. That paragraph 64.3, the final sentence. The courts have recognised that the tort of misuse of private information differs from the law of confidentiality. It protects not only the secrecy of private information, but also the intrusion associated with its publication, and may apply even if the information is already public to some extent. Reference to PJS. See also Lord Brown, the Lord Brown case at E1075. Paragraph 24. The first question under Article 8 is whether, in respect of the disclosed facts, the claimant has a reasonable expectation of privacy in the particular circumstances of the case. That is the relevant question, whether there was a previous confidential relationship or not. And to similar effect, page 107.8, paragraph 31. A relevant factor under MOPI Stage 1 question was whether the person who received the information knew or ought to have known that it was fairly and reasonably to be regarded as confidential or private. That last three lines of paragraph 31. So the concepts are really being elided. See also Murray, paragraph 24 at E111112, paragraph 24. At H, Roman 2, although the origin of the cause of action relied upon his breach of confidence, since information about an individual's private life would not in ordinary usage be called confidential, the more natural description of the position today is that such information is private, and the essence of the tort is better encapsulated now as misuse of private information. So it's really summarising what Lord Nichols had said. And paragraph 36 in the Prince of Wales case, that's E1054. So I can just ask my lords to read paragraph 36. So we say, with the benefit of those citations, it follows that the Bloomberg article, the Bloomberg argument and the approach of Professor Moore, upon which Bloomberg placed such reliance, the approach that a person in ZXC's position should only be able to pursue a claim in breach of confidence rather than privacy, and then only in very limited circumstances where the Marcel principle applies, the traditional definitions of the duty of confidence is simply, we say, another way of saying that a suspect should not have any remedy against the media when the media publish leaked confidential information revealing a person's status as a suspect in criminal proceedings or criminal investigation. It must be left to the owners of the confidential information to take the action to protect the confidentiality. That seems to be the argument. In that scenario, of course, ZXC would have been completely unprotected, given the reluctance in this case of the UK LEB to litigate. They had, as you know, in fact, objected strongly to the leaked information being published, and that fact was concealed from the Mr. Justice Garnham. And as Mr. Justice Nicklin said, if it hadn't been concealed, the injunction would probably have succeeded. But the argument amounts to saying only the UK LEB should have been able to protect the confidentiality of this information, and it doesn't lie at the suit of the suspect to bring a privacy claim. In effect, the purpose of the submission would be to end privacy protection for criminal suspects at their own suit. And so in my submission, the approach of the courts below on this issue were absolutely right, bearing in mind how the tort has emerged, and, if you like, the interchanging descriptions of the information in question as confidential or private. They are, in effect, the same concept in this area. My last part is part 5. Did the lower courts wrongly strike the balance? My learned friend was really very brief, and in my submission, I don't, unless I am asked to say more than, this is a hopeless submission if Article 8 is engaged. On the facts of this case, it's hard, frankly, to conceive of a worse case to pursue by a media organisation seeking to suggest that the balance was struck in the wrong place, bearing in mind the findings of fact below, and specifically that nobody in Bloomberg, there's certainly no evidence of anyone in Bloomberg even applying their mind to the public interest issue. And so an appeal to editorial latitude in the context of this balancing exercise, in my submission, is really quite hopeless. My Lords, unless I can assist further, those are our submissions.
Could I pursue with you a little more the issue we were discussing about the recovery of damages?
Yes.
I've just been trying to think about it a bit. We're concerned with the publication of private information that a person is under investigation.
Yes.
And we know, for example, from Slim and the Daily Telegraph, that it's probably just a matter of fact in any event, that that the publication of that information does not imply guilt of the offence.
Yes. It's Chase level 2 or 3.
Yeah, but rather it does imply that there are grounds for investigation.
Yes.
And that's not disputed. And so, in principle, you should be able to recover damages for the deleterious impact on you of the publication of that information.
Yes.
That you're under investigation, whether it's true or false.
Yes.
And if the investigation has been closed by the case by the time the case comes to trial,
Yes.
then there's no problem.
Which is the Cliff Richard case.
Yeah.
I mean, there never was a case that began.
Yes. Now, if the investigation is still ongoing and it results in your being charged, then one might think that that's a reason why you shouldn't be awarded damages for, whether you call it reputation, loss of reputation, or you call it the distress caused by the way you are now regarded by other people.
Yeah.
Because the charge itself would be, if anything, a more damaging event than, and that's something which is properly published.
Yes.
Yeah. So, so if the investigation is still ongoing, I suppose the court could stay the proceedings to wait wait the outcome of the investigation.
Yes.
And see if you're going to be charged.
Yes. Yes. I mean, most cases, fortunately, don't take as long to investigate as this one. I mean, this case has been going on, as you know, at an investigation stage with no one arrested.
Yeah, but this type of case always takes a long time.
This is longer than most. But yes, my lord.
I mean, so far as that element, and if you're trying to, if you're seeking damages specifically in respect of that element, then I'm wondering if that's at least a solution in some cases.
Yes.
The court would have that discretion.
Yes. My lord, absolutely. Of course, in a situation where it is clear that a charge is about to be laid, I think it's inevitable, if the claim is based on the fact it's not true, that would be adjourned, because it would be wrong on a number of bases, quite apart from the publicity that could be given to a pending criminal trial, which would be damaging. I can't see there would be many claimants who would want...
I think my lord's point was very slightly different from that. It's that the damage to reputation occurs at the point when a public charge is made.
Yes.
So in a sense, if you reach the point of public charge,
yes,
all the facts relevant to reputation are known by that stage.
Yes.
I think my lord was addressing at a slightly earlier stage where the investigation is still going on. It's unknown whether there'll be a charge.
Yes.
But one would hope the investigation would proceed moderately quickly.
Yes.
I take your point, this is an unusual case.
Yes.
The idea of a stay at that stage being, let's wait and see if there is a charge.
Yes. 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 I mean, I can see practical reasons why that may just be kicking it off into the long grass for an indefinite period. And I guess it would depend on how determined the claimant was to push for a trial, regardless of that aspect of the case.
Just out of interest, would there be procedurally be scope for damages to be awarded, if you like, on account for part of the loss claims,
yes,
but staying over potentially larger damages?
Yes. That's one of the...
Sorry, you're saying yes, that would be possible?
Yes, that would be a possibility.
Right.
Yes. Yes.
Personal injury cases, you get provisional damages, but that was on a statutory basis.
Yes, indeed. Yes.
I haven't...
Yes.
Damages on account I haven't as yet come across.
No.
No, if you were able to give us chapter and verse on that, that would be very helpful.
Yes. Can I come back to you rather than just instinctively respond? I'd give a more...
Well, we are ahead of time. Would it be useful if we were to rise slightly early?
Yes.
And give you time to research that point?
Yes, we'll do our best over lunch.
We could come back to that at 2 o'clock if you've found out the answer by then.
Yes, certainly.
Very well. Well, in that case, we'll rise now.